Hello, welcome to Cutler Legal, Basic Law. Today we're going to talk about jurisdictional language in a contract. First of all, what do I mean by jurisdictional language? It's usually one of those clauses at the end of the contract you all skim over and say, it's just boilerplate. It's the language that says if a dispute arises, what state or county or both the lawsuit should be brought in, and what law should apply. First question, is it important? Is it necessary? The answer to both of those is yes and yes. It's important and it's necessary. Not necessary to make an enforceable contract, but necessary in case something bad happens. Meaning, if a dispute arises as to the contract or under the contract, then the issue is where is the lawsuit brought? And if you're, let's say, from Georgia, and you enter a contract with someone in Kansas, and you put as jurisdictional language that any dispute arising under this contract is to be brought in the state of Kansas, that means that you are going to have to go from Georgia to Kansas to enforce the contract. Or if a lawsuit's brought against you, you're going to have to travel to Kansas to defend yourself. That's expensive, both in your travel time. Getting a lawyer in a foreign jurisdiction is always scary and expensive and problematic, and can ultimately discourage somebody from bringing a lawsuit to enforce legitimate rights. Most importantly, in a contract, if you're the one likely to bring the lawsuit, let's say you're selling goods and you're getting paid over time, you're going to deliver the goods, so that probably won't be the breach. But what might most likely be the breach is the payments. The payments stop. Then you want to spend as little money as possible to bring that lawsuit, and one of those costs is where you bring it. And if you have to travel far or hire lawyers in other states, that's an added cost. All right. There are two components to a jurisdictional provision. The first component is what law applies. It says, often they say, the laws of Kansas will apply. That means that the case can be brought in any jurisdiction, but when it's brought in that jurisdiction, the laws of Kansas are to apply. So the courts are to apply Kansas law, even if the case is, let's say, brought in Texas or Georgia. The second type of provision is any lawsuit must be brought in a specific state, and it's often right down to the county, this particular county or this part of the state. And under those circumstances, the lawsuit must be brought in that area. So if it says lawsuit must be brought in Kansas, then the lawsuit must be brought in Kansas. And if it's brought in another state, it's grounds to move to dismiss or transfer the case to Kansas. So often in the jurisdictional provisions you have, the laws of Kansas shall apply, and any suit brought to enforce or arising under this contract shall be brought in the state of Kansas. Meaning Kansas law applies and the lawsuit must be brought in Kansas. On these jurisdictional provisions, you have multiple states. Let's say you're dealing with a person in Kansas, you're from Georgia, and you both can agree, well, let's have both Georgia and Kansas apply, so either one of us can choose which state. That's totally fine. Or if you leave it blank and you say nothing, then the lawsuit could be brought in any state as long as the state has jurisdiction. So a person could bring it in Kansas, since that's where some of the parties were, most likely, or Georgia. Or maybe, let's say, if the contract was performed in Texas, maybe the case could be brought in Texas. But when negotiating a contract, you always try to have the state that you live in is the state where the lawsuit's brought. Do not look at that as boilerplate language, otherwise it will cost you. I hope that was helpful. Thank you very much.